Understanding the law is the first step to fighting back. Here's what the IRS just decided, and what it means for your family. Tax season is here, and if you hold a green card, what you do or don't do on your tax return can cost you your permanent resident status. This is not an exaggeration. The IRS and immigration enforcement are more connected than most people realize. And this year, that connection carries more weight than it has in decades. We are going to walk through 5 things every green card holder must understand before filing this season. These are not technicalities. Each one of them, handled wrong, can put you on a path toward removal proceedings. The first thing to understand, the day you receive your green card, the IRS treats you exactly like a United States citizen for tax purposes. That means worldwide income, everything, a business you run in your home country, rental properties abroad, a side income from another country, foreign investments, all of it must be reported on your U.S. tax return. The United States is one of only 2 countries in the world that taxes people based on residency status rather than physical location. The other is Eritrea. The moment you become a lawful permanent resident, this obligation begins, and it continues until you formally surrender your green card through proper legal channels. This surprises a lot of people. Many green card holders don't learn this until they are already in trouble with the IRS, or worse, until it comes up during their naturalization interview. Your accountant or tax professional can use legal tools, the foreign tax credit, the foreign earned income exclusion, to reduce what you actually owe. But the obligation to report exists regardless. Failing to report is not a technicality. It is a legal exposure. The second thing you need to know is about the form itself. Green card holders file Form 1040, the same form U.S. citizens use. There is a different form called the 1040 NR. That NR stands for non-resident. Filing that form as a green card holder sends a signal to the IRS that you are claiming non-resident status. That is a legal problem. USCIS can interpret the 1040 NR as evidence that you consider yourself a non-resident, which can be used as grounds to argue you have abandoned your permanent residency. That is a direct threat to your green card. This is not a hypothetical. Immigration judges and USCIS officers review tax returns as part of naturalization applications and adjustment of status cases. The form you choose matters. Always file Form 1040. Even if you lived abroad for part of the year. Even if most of your income came from another country. Even if you owe nothing after credits and exclusions. The form is 1040. The third thing is what happens when this goes wrong. Specifically, how your tax history affects your path to citizenship. When you apply for naturalization, you are evaluated on something called good moral character. This is a legal standard, and it covers a period of years, typically 5 years before you apply, or 3 years if you are applying based on marriage to a U.S. citizen. Outstanding taxes you have made no effort to resolve can be used as evidence against good moral character. An IRS payment plan, an offer in compromise, active communication with the IRS. These show effort, and they matter. But a tax bill you have simply ignored is a different situation entirely. More seriously, if an officer determines you intentionally failed to file or intentionally misrepresented income to evade taxes, that can be classified as a felony under federal law. A felony conviction involving moral turpitude can make you inadmissible and subject you to removal. This is the path from a tax mistake to a deportation proceeding. The fourth thing is more encouraging. There are real tax benefits available to you as a green card holder. The first is the foreign tax credit. If you paid taxes to a foreign government on income earned in another country, you can claim those payments as a dollar-for-dollar credit against your U.S. tax liability. If you paid $10,000 in taxes to your home country, you can reduce what you owe the IRS by $10,000. The second is the foreign earned income exclusion, filed on Form 2555. For tax year 2025, this allows you to exclude up to $130,000 of income earned abroad from your U.S. taxable income, if you meet certain residency or physical presence requirements. The third is something many people overlook entirely: tax treaties. The United States has tax treaties with dozens of countries. Depending on your country of origin, there may be additional benefits, reduced rates, or specific exemptions that apply to your situation. These vary significantly by country, so it requires looking up whether your specific country has a treaty with the U.S. and what it covers. A qualified tax professional who works with immigrants can walk you through all three of these tools. The goal is full compliance while minimizing what you actually owe, and that is completely achievable for most green card holders. Stay informed and know your rights. Record today, protect tomorrow.